Yes. Yes, please go. I've formulated a short note also, if I can circulate. Yes, sir. Before just coming to the reference questions, I would like to first say about the object which was behind introducing Section 319. The object was it was introduced in order to cure some mischief which has been committed by either the investigating agency or some witness during the trial. So this power was introduced and given to the court so that the real culprit or the person who is seems to be a culprit who has committed some offense may not go scot free. Now, this is a enabling provision which should be construed liberally, and technicalities which are handmade. My submission will be they should not allow a person who is apparently an accused who can be tried along with the other and seems to have committed an offense to go scot free. Now, the court cannot be a mute spectator to all this. That somebody who seems to be an accused who has committed the offense and can be tried with the other accused should be go scot free only because some irregularity or some decision of the case of 319 application was decided either simultaneously or on the same day because of maybe delay on some technicalities. The application was decided later on, maybe on the same day. That is the reference. So if the case is decided, the application is decided on the same day, but it was moved earlier, and the court had opportunity of looking at the facts from where the court could come to the conclusion that this person is also one of the accused who are being tried. He can also be tried along with them and can also be an accused in the case. He should also be tried and his trial should also be there. Now, this is a new law, and I'll refer to Hardeep Singh's judgment, wherein this object was also taken care of. With my submission, I'll refer to Hardeep Singh's judgment, page 21. Mr. Raju's compilation, we are all using. 112 page of Hardeep Singh's judgment, page 21 of the compilation, para 8. Yes. The constitutional para 8, the constitutional mandate under Article 20 and 21 of the Constitution of India provides a protective umbrella for smooth administration of justice, making adequate provisions to ensure a fair and efficacious trial so that accused does not get prejudiced after the law has been put into motion to try him for the offense. But at the same time, also gives equal protection to the victims and to society at large to ensure that the guilty does not get away from the clutches of law. For the empowerment of courts to ensure that the criminal administration of justice works properly, the law was appropriately codified and modified by the legislature under CRPC, indicating as to how the courts should proceed in order to ultimately find out the truth as to so that an innocent does not get punished, but at the same time, this is important, but at the same time the guilty are brought to book under the law. It is these ideals, as enshrined under the Constitution and our laws, that have led to several decisions whereby innovating methods and progressive tools have been forged to find out the real truth and to ensure that the guilty does not go unpunished. Now, para 9, the presumption of innocence is the general law of land, as every man is presumed to be innocent unless proven to be guilty. Alternatively, certain statutory presumptions in relation to certain class of offences have been raised against the accused, whereby the presumption of guilt prevails till the accused discharges his burden upon an onus being cast upon him under the law to prove him to be innocent. These competing theories have been kept in mind by the legislature. The entire effort, therefore, is not to allow the real perpetrator of an offence to get away unpunished. This is also a part of fair trial And in our opinion, in order to achieve this very end, that the legislature thought of incorporating provisions of Section 319 CRPC. It is with the said objective in mind that a constructive and purposive interpretation should be adopted that advances the cause of justice and does not dilute the intention of the statute conferring powers on the court to carry out the above mentioned award, object, and purpose to try the person to satisfaction of the court as an accomplice in the commission of the offence that is subject matter of the trial. So, the important is that it should not be the cause of justice should be taken care of, and then it should not dilute the intention of the statute. Now, para 10. In order to answer the aforesaid question posed, it will be appropriate to refer Section 351 of CRPC in old code. Now, this is the Law Commission's recommendations which were read yesterday. These recommendations also tell about the object of 319, that the person who seems to be the real culprit, or a culprit in an offence which has been committed, should not go scot-free. For that, the Law Commission also recommended that it should be amended in such a way that they should not go scot-free. I can read these two, otherwise it was read by my learned senior counsel on the other side. I can read two. It happens 24.8. It happens sometimes, though not very often, that a magistrate hearing a case against certain accused finds from the evidence that some person other than the accused before him is also concerned in that very offence or is connected offence. It is only proper that the magistrate should have power to call and join him in the proceedings. Section 351 provides for such a situation, but only if that person happens to be attending the court. He can then be detained and proceeded against. There is no express provision in 351 for summoning such a person if he is not present in court. Such a provision would make 351 fairly comprehensive, and we think it proper to expressly provide in that situation. Then 24.81, how the cognizance is to be taken. It is 190 is explained, and then it is said that it does not make any difference. It will start from that stage. Now, kindly have para 12, page 23. Section 391 CRPC, not para, sorry, 319, not para 12, Section 319 CRPC. Yes. Springs out the doctrine of judex tamentur cum nocens absolvit. Judge is condemned when guilty is acquitted. And this doctrine must be a beacon light while explaining the ambit and the spirit underlying the enactment of Section 319 CRPC. This is very important. The question will be as to why the enactment of 319 was there. Yes. 13, it is the duty of the court.
The only difference is that in earlier 351,
Please.
a person will be proceeded only
Present
before the court.
Yes, yes.
The addition that is now, even if a person is not before the court, he can be
summoned.
Brought to the trial.
Yes, that is the only difference. But 351 and 319, they are the same section.
Basically, you are relying on mischief or hidden rule.
Yes, yes. 319, because if he is not present, then there was a lacuna. So he couldn't be. Now it is said that he can be summoned and then tried. And then 190 is explained regarding the cognizance. Now, then 12. I read 12 to explain only that the ambit and the spirit underlying the statute of and enacting 319.
Of time should not go scot.
Grateful. Because 351, the word used was detention of offender attending court. So that was a technical hitch which the real culprits used to use and go scot-free. That is why now it has been changed and persons appearing to be guilty of offence. So, my lord, now 319 says if a person appearing to be guilty of an offence, even if not before the court. So, my lord, I am saying that the object, my lord, behind introducing 319 is that the person who appears to be guilty should not go scot-free, only on the technicalities. That is why, my lord, amendment, a few lines added, so that they were trying to, my lord, avoid the law by making this technicality, using this technicality, and the real culprits used to escape the law. That is why, my lord, kindly have para 13 also of this judgment. It is the duty of the court to do justice by punishing the real culprit, where the investigating agency for any reason does not array one of the real culprits as an accused, the court is not powerless. In calling the said accused to face trial, the question remains under what circumstances, at what stage would the court exercise its power as contemplated in section 319 CRPC. So, my lord, I have read this just to say that by mere technicalities, I'll come to the, my lord, reference also. The person whom the court finds to be a person who might have committed the offence and needs to be summoned and tried with the other accused cannot go scot-free only by saying that there is some ambiguity and the timing of the passing of the order in the application under 319. Now, my lord, it will defeat the entire my lord, intention of the statute. The intention is that the culprits...
Advocate General, after discussing all these aspects, finally Hardeep Singh came to a conclusion that once the judgment is pronounced,
Lord, that is why.
after explaining
Lord, I will explain that
background,
also.
everything,
Lord,
you know.
I will explain also with my,
47.
Lord, with my lord's permission. I am saying,
Yeah.
Lord, Hardeep Singh never visualized the fact that it is on the same day. That is why, Lord, the reference.
Because from what you are reading, why is not in doubt? How is the question?
Yes, Lord, I will come to that also. Lord, I am just trying to show to the Honorable Court that what was the intention and the object to introduce 319. Now, Lord, Hardeep Singh never visualized this situation that if it is on the same day. I'll come to that also. I am, Lord, only on the object to show that if it is on the same day, what will be the effect? Will, my lords, allow the person whom the court seems to be, my lord, feels is a culprit who should be tried, should go scot-free only because the judgment and the application is decided either simultaneously or one after the other. That is why I am referring to the object. If, my lord, feel the object will be defeated by, my lord, this mere technicality of application being decided immediately after the judgment or simultaneously, then, my lord, the entire statute, the intention behind that will be defeated. So that is why I am referring to the object.
But conviction can't be on moral grounds, no?
It cannot be, my lord. My lord, it is to cure the mischief. Now, my lord, I'll give an example. My lord, I tried yesterday also. My lord, if the complainant says that A is the person who has committed the offence, the investigating agency finds B and C, they will bring them to the court. B and C are being tried, who are not, according to the complainant, the persons who have committed the offence. Now, my lord, application is moved by the complainant when he gives an evidence that he is the person, A is the person who has committed the offence. Now, my lord, by the time the judgment is pronounced, and my lord, on the same day, application 319 is also allowed, and A is summoned. My lord, my respectful submission is, and I put a question to myself, will, my lords, allow A to go scot-free only because the investigating agency played a mischief? Investigating agency allowed the A to escape from the clutches of law by making B and C accused. The complainant never supported.
If the complainant is examined,
Please, sir.
and in the examination in chief itself, he points about the culpability of A,
Please.
then would it not be that proper stage to take action under 319?
Yes, Lord, yes, Lord, yes. I am only on the decision of 319. Lord, I am only on the decision of 9.
So if from the evidence of the complainant itself,
Please.
it is known that A is also culpable, then should the trial judge wait for a conclusion of the trial?
Lord, he will not. What happened in the present case, Lord, I'll
I am
come.
only giving
Well, he will not.
And about the example which you have given.
Well, I am on the point, well, if the court decides on the same day, well, because this also Hardeep Singh never visualized. I am only visualizing if well, this is so. I say well, even 1 out of 100. But my respectful submission is even 1 out of 100 if he is allowed to go scot-free like this. This situation may also arise sometimes where, like in the present case, the Honorable High Court had ordered the trial to be expedited. I'll come to the facts of the case. But it may also come sometimes. It may be visualized also that this may also happen. The question will be whether this ambiguity only will allow this man to go scot-free. That is why I was referring to the object. Kindly have this judgment, Manjeet Singh judgment, page 152. Page 152 of the compilation.
Yes.
This is judgment of Manjeet Singh, where Hardeep Singh was followed.
What page?
Well, this is page 152.
150.
152 of the compilation, para 34 of the judgment.
Para?
Para 34,
Yes, we have.
the ratio.
Yes.
Page 152, para 34.
Yes.
Yes.
Yes, we have.
The ratio of the aforesaid decisions on the scope and ambit of powers of court under 319 CRPC can be summarized as under. That while exercising the powers under 319 and to summon the person not charge sheeted, the entire effort is not to allow the real perpetrators of an offence to go away unpunished. For empowerment of the courts to ensure that criminal administration of the justice works properly. The law has been properly codified and modified by the legislature under the CRPC, indicating as to how the court should proceed to ultimately find out the truth, so that the innocent does not get punished, but at the same time the guilty are brought to book under the law. To discharge duty of the court to find out the real truth and to ensure that the guilty does not go unpunished. Where the investigating agency, for any reasons, does not array one of the real culprits as an accused, the court is not powerless in calling and the said accused to face trial. Section 319 CRPC allows the court to proceed against any person who is not an accused in a case before it. The court is the sole repository of justice and duty is cast upon it to uphold the rule of law, and therefore it will be inappropriate to deny the existence of such powers with the court in our criminal justice system, where it is not uncommon that the real accused at times get away by manipulating the investigating or the prosecuting agency. Section 319 CRPC is an enabling provision empowering the court to take appropriate steps for proceeding against any person not being an accused for also having committed the offence under the trial. Now, this, then 319(1), which I read, then regarding the fact that it is mischief, then how the procedure. Now, with mindless permission, I'll read 319 again because that is the under reference. Lord. Lord, 3191.
Yes, we have.
Lord, 3191. It was read many times, Lord. I also read yesterday. Lord, it is the first is 319.1 to identify and to see who is the person who can be summoned. So, Lord, where in the course of an inquiry and offence, it appears that from the evidence that any person not being the accused has committed any offence for which such person could be tried, together with the accused, the court may proceed against such person for the offence which he appears to have committed. So, this is, I said, Lord, yesterday also, to identify as to who is the person who can also be tried with the persons who are being tried by the
No
court.
difficulty. The question is at what stage
But I'll come.
a power can be
I'll come to that.
exercised.
But now, but 4. I am on the procedure. But 4 because but the argument raised
How
was.
do you ignore the words in the course of any inquiry into
Please,
or trial?
please, kindly, but then
That-
in an offence.
So we fully agree
Please,
that the source to exercise the power is under 1
please,
and 4 is procedure.
please.
If the source is under 1, then 1 itself specifies the stage at which such a power can be exercised.
But it is well during trial. I'll come to para 47 of Hardeep Singh Millard after this because the argument raised, and of course yesterday Millard I had argument raised was that a person Millard who is summoned like this should be tried with the other accused only. That was the argument raised. That is why I am raising Millard. I am coming to 319.4 by saying that 319.4 the trial of this person has to start de novo. The evidence has to be recorded. It is from the very first stage that the trial will start. So, that argument that it should be this person who is summoned should be tried only along with the other accused does not hold good ground.
No, I think they said the court will have to apply its mind whether it should be tried separately or together. Thereafter, make a decision.
I said this was Mr. Patwalia's argument. Of course, thereafter, it was changed. But this was the argument raised.
You have to only take into consideration the changed argument.
All right, I'll come to that. I'm so grateful. I thought I should
post amendment position.
I thought I should hammer on the position which is in my favor. So I tried that. 319.4. So he can be tried de novo from the very from the stage at which the other accused were.
Mr. Nagpur also agreed. Mr. Nagpur said that
Yes.
will have to be taken by the trial court because at that time it may be in the interest of prosecution that a joint trial would be in the interest
The
of.
question will be, at what stage this decision has to be taken? I'll refer to that.
The question is at what stage the power given under subsection 1 has to be exercised.
I'll come to that. Now, as far as 319.1 is concerned, this is the reference, that when it can be done. First reference, first question I'll try to answer, that the trial court has power under 319 for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of the conviction rendered on the same date before the pronouncing of the summoning order. I read the object and scope and the intention behind 319. Now, this situation was never visualized by Hardeep Singh also. So they in para.
Forget about Hardeep. The first principle of interpretation is plain and literal. So just try to focus on this word in course of any inquiry into or trial. What is the scope of this?
I'll come to that. Because the question will be whether it can be on the same day when the judgment is passed or it has to be earlier to the judgment passed. That is the only ambiguity in the present case.
The question would be what would be any inquiry into or trial?
Yes. The trial will end by the judgment being pronounced, being delivered.
That you also agree.
Yes,
conclude after the
judgment being delivered. I'm using word with very cautiously, very cautiously I'm using the word delivered. So when the judgment is delivered, the trial will come to an end. So and thereafter the court will become functus officio. So question will be, I said, the ambiguity in certain cases can be of many types. Now, Well, with the reference being made, well, I have visualized many situations as to what can happen after 319 application is moved. Kindly have my note, page 3. Different situations which may happen and what is the law. The third page.
Yes, sir.
Well, this is answer to question number 1, where I have tried. Well, kindly have this first situation is where application under 319 CRPC is filed and decided before conclusion termination of the trial. That is before pronouncement of judgment and order of sentence when applicable. And this order of 319 attained finality during the pendency of such trial. When 319 application is moved, it is decided before the conclusion of trial.
No dispute on that.
No, yes, well, I'm just visualizing different situation. There's no pendency, no application filed, 319 application final. Then, it is of course legal. This can be done. Second situation, kindly have next page. Where an application under 319 is moved and decided before the conclusion or termination of the trial. That is before pronouncement of judgment and order of sentence when applicable. Thereafter, order under 319 is pending challenge before the higher courts without any stay on the ongoing trial, that is trial of the co-accused. Meanwhile, the trial qua the other accused is concluded and judgment pronounced. Now, where the 319 is moved, allowed before the conclusion of trial, but somebody has gone against the order.
Covered by Shashikant.
That will be covered. I am only on the different situation. That will be covered by Shashikant, wherein the trial of the co-accused has already concluded. So
In this case, the power is exercised during the stage of the trial.
yes, I am only contemplating different situation wherein the court has come across. Now, Shashikant of course refers to that and says yes, the trial of this person will go on de novo without having any effect of the fact that the co-accused trial has already concluded. So that will be the second situation. Third is the present situation, where it is said when application of 319 is decided simultaneously on the same day, when trial is concluded, the judgment pronounced and the order of sentence passed. In such a scenario, till the conclusion of trial, the learned court does not become functus officio. This is what is to be brought to the notice of the court. If the court becomes functus officio and the application is decided thereafter, then the effect will be different. But if it does not become functus officio, the court still has the file with it.
Special effects.
They're coming from Punjab.
Special effects.
Special effect on situation number 3.
That is the main situation that we have been harping for the last 3 days, but coming to it only in the end.
All right. Yep. Yes. Yes, sir.
Now, it is on the last day, it is said on the last day when both are decided, that is the judgment is also pronounced on the same day and the application is also decided on the same day. Now, in that also there can be situations. One, that there is no clarity as to which order was passed before and which was passed earlier, which was passed later. So, there may be ambiguity in that also, since the reference is there. I am just trying to assist on that. There may be ambiguity in that the court is not clear. It is not coming forth before this honorable court as to which order was passed earlier and which was passed later. Then, I will say under 354, it is only an irregularity. Kindly have section 354. Sorry, 465. I'm sorry, 465. 465 CRPC.
Yes, sir. 465.
465.
Yes.
Subject to provisions herein before contain no findings, sentence or order passed by court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the complaint, summons, warrant proclamation, order, judgment, or other proceedings before or during trial, or in any inquiry or other proceeding under this code, or any error or irregularity in any sanction for prosecution, unless the opinion of that court, a failure of justice, in fact, has occasioned thereby. Now, my lord, the situation I am just contemplating, and in the present case also, my lord, herein, my lord, I referred the order summoning 319 order, my lord, says that the conviction, the court has convicted the other co-accused. Now, court does not mention about the sentence. For that, I referred, but I can refer to the order wherein 319 minute summoning was allowed. In that, the court has specifically said, I can read with my lord's permission.
Page 130
Page 130 minute
of the SLP.
of the SLP. But this is page 130. Kindly have fourth line, second unnumbered paragraph. So this is
Yes, we have 130.
as the things stand out.
Yes, we have. Just one second. Yes.
As these things stand out, this FIR number 35 was registered and challan against 10 accused was presented by mentioning that after investigation, this is important, after investigation, the challan against the remaining accused will also be filed. But till date, no challan is presented against other accused whose names are being mentioned in the application of 319 CRPC, void by separate judgment. All the accused against whom the challan was presented, except one, are convicted today. So, what I read it again, whose names are mentioned in application of 319 CRPC, now not full stop, void by separate judgment, all the accused whom the challan was presented, except one, are convicted today. The proceedings of this application were separated from the main case. Now, the court mentions here they are convicted today. So, court does not mention about the sentence. Because the question of sentence was taken later on. Now, my lord, kindly have 354.
Can you say with certainty?
Yes, my lord. If it is not certain,
Not
even
only
then
on-
I have a case, my lord.
Whether as a matter of fact, it has happened in the same sequence that first conviction, then 319 and then sentence.
My lord, otherwise,
No, not on conjecture and surmise.
no, my lord.
Matter of fact.
My lord, I'll be on facts. Otherwise, the court would have mentioned in the order that wide judgment I have convicted and sentenced those persons. Definitely, they would have mentioned. My friend was arguing, my lord, case of state of UP, in which it was clearly mentioned, convicted and sentenced, and then application thereafter. If there's some ambiguity,
But then
irregularity,
Rosenama would show that
please, my lord.
if it has happened in that sequence, I don't know what is called, we call it Rosenama in Maharashtra.
Zimni orders, my lord. Zimni orders.
On my turn, I will clarify. It's very, very clear in the Zimni order. Crystal clear.
No, what would have been the position if it was a case of acquittal? No further sentencing,
One
nothing.
is
Then, my lord, they would have been
The matter
acquitted.
ends at acquittal.
So one
Yes,
is
my lord, they would have been acquitted even before 313 or acquitted thereafter, functus officio. Then I had no case.
So therefore, there must be only one correct position, firm
Please.
position.
Please.
It can't be that the court does not become functus officio if it is an order of conviction, and it becomes functus officio if it is an order of acquittal. Because sentencing is only a consequential order after conviction.
But I'll read 350.
There must be a firm position.
Which is the provision for sentencing?
My lord, 354, my lord, may kindly read. My lord, the sentence will be the part of the judgment, only then it is delivered. 354, kindly read, my lord. 354.
Consequential.
Yeah.
354, my lord. shall specify the offence for of which the section of IPC or other law under which the accused is convicted and the punishment to which he is sentenced. The judgment will be complete only when the sentence is also mentioned. It will not be complete. So, para 47 of Hardeep Singh's judgment furthers my case that pronouncement of judgment and the delivery amounts to conclusion that the 319 cannot be used after the sentence functus officio, I said, in case of acquittal, as soon as the judgment is pronounced, because no question of sentence in that case. But in case of conviction, the accused have to be given opportunity to be heard before the passing of sentence. Then 354C, wherein the judgment will be complete only when the order of sentence is passed. Now they are relying upon only this paragraph of the order of 319, that this was passed earlier, conviction order was passed earlier, and 319 order was passed later on. That is the only line they are relying upon. That is why I am also on that line. Otherwise, they don't have anything to say that this judgment was pronounced earlier and the order on the 319 was passed later on. They say, because it is mentioned in the order itself that the persons have been convicted, the judgment has been passed of conviction. I say, all right, conviction is there, but then the sentence is passed thereafter. Otherwise, the court would not have missed that part, saying that convicted and sentenced. Even otherwise also, I say where this honorable court has slightest of doubt, regarding the fact as to which was earlier and which was later, I can say it is simultaneous. If it is simultaneous, it is irregularity. The culprit cannot be allowed to go scot-free only because the court either pronounced one of the applications order in the one of the applications later and then the sentence thereafter, or pronounced it on the same day. Well, the entire object of 319 I read is so that the person who the court seems to be an accused who has to be tried along with the other will go scot-free by this mere technicality as to when this was pronounced. But by Mr. Nagamoto also yesterday, it is only when the sentence is pronounced then the the judgment is complete. And
Maybe to that extent you appear to be right, Mr.
I'm
Advocate.
so grateful, but I am right somewhere. But I'm so grateful. I'm just trying that, but I'm just trying that.
Maybe
Lord,
to-
then, Lord, if
You appear to be right. We have not said we are right.
that is what, Lord, under 319, it appears that he is accused. Because he will come, he is not convicted. He will be tried by the court and let off. Lord, only one thing, if my lords kindly permit me here. Lord, if this is allowed, complaint doesn't have
Anyway,
any.
we are not answering on facts. We are only declaring the law,
Yes, yes,
leaving it.
yes, Lord, yes.
It's your headache there.
Lord, I am contemplating only the situations that on the same day, if the situation is that the conviction is there but sentence is thereafter, on the same day the sentence and the conviction is first, then the order. On the same day, Lord, there is something else that it is simultaneous. So, Lord, it is I am trying
But
to
we must
answer.
also keep in mind,
Please.
in a case where in the cross-examination he concedes and you, in a case, not in this case, you manufacture a witness, make an application under 311, ask him to bluff something and issue 319.
Well, Lord, two situations in that. That is the court which has to see whether 311 will be allowed. Then they have a remedy to challenge 311 which has not been done in the present case. That attained finality they could have done at that time. Now, Lord, coming here and the investigating agency try to shield them rather than, Lord, be against them. The initial challan presented saying that other accused, the challan will